dan is zooming in near rested was you home we said home treat war adenim
na ni coach
dan kwachiri no mo kwachiri akra no mo rested was you home wo kuro na nya hoto
nanim hanchom
as Otchere
said was you home with nose mask in voyo
it is already Kelvin Taylor a free man as he said obetimi na Ghana has without having any court case with anybody as long as the law is concerned. Now, Empenifo Kazim say yes, bibi enokoka bibi emetimi nya asemka. Before I be share say make sure so be like you be subscribe you and wa share amafo from so enya bi. Ahwe enti no bibi bisa say die ne see ye
to what has just happened at the Supreme Court. You are moving the motion on behalf of
you saw what happened. So what do I have
how
to
do you receive this news from the Supreme Court? The decision of the Supreme Court. That's exactly what you wanted. You got what you wanted.
We are happy to have that decision. And our client is now a free man.
There was an issue about why it took you that long time before eventually having this done today.
Yeah, the authorities are clear that when the decision is a nullity, it can be quashed anytime. So there's even the case of Cable Metal versus Barclays Bank, where the decision was quashed 9 years on.
4 versus 1 decision our court. It's now Ushema. A judges say out of 5 no nipa 4 and I say almost support Kelvin Taylor say asem no no case and I feel nipa baako and so no die osu abrobo mitim nya mitim enya ade a obetutu ne 9 da enti na chese omoko wo mu wie case no na chese Kelvin Taylor wa wini case no over Justice Eric Che Bafo enti na se won se Kelvin Taylor ni video ene na mabonti baby a this is the reason why enti a okopie mu e court.
My friend Abronye will scandalize the court. He can say anything about the Supreme Court. And then they'll issue a warrant. And then he'll come to court and say, I have a certiorari. Because today, they were citing Kennedy Japan. That, Kennedy Japan too scandalized the court. Didn't he scandalize? And then they went and then they removed him. So Abronye will come and say, na Kennedy Japan scandalized court. I'm more man is certiorari. Kelvin Taylor scandalized. And I made them scandalize. I'm more man is certiorari. And then the confusion will start. A court will say they won't give certiorari. MPP will put people on the streets. Police will shoot at them. And then we are turning it upside down. So Abronye will go and do that. And then he knows what he's doing. He is sure about what he's doing. Then they'll go and catch him and take him to a Kumasi High Court. And he'll say, you won't go. You won't go. Then he'll bring certiorari to the Supreme Court. And the Chief Justice may or may not list it. I don't know. Or he lists it and then the certiorari fails. And then the MPP say, hey, why is the certiorari failing? When this one? And then they say, today, then we are going. They are in opposition. They don't have much work to do. They are looking for something. And then they charge in Kumasi and put 1 million people on. Kill them. And let's see. And whose fault would it be? So you were in court this morning, very briefly. So, what happened?
Well, so the court ruled. So initially when the party, that is Kelvin Taylor and his lawyer, the Leonard Peter Okujeto were in court. Lawyer, the states, the Attorney General's Department, no representative came from the Attorney General's Department. In fact, Justice...
No one.
That is so. I mean, there were lawyers from the Attorney General's Department for other matters, but not specifically for this one.
So the Attorney General was not represented?
Yes. And indeed, I remember Justice Amadou Tanko insisted and said that everybody must see that indeed the Attorney General's Department was served and they did not appear. Indeed.
They did not appear?
Yes, there was no representative.
But they can do that? It's easy to do
well, that? Well, you may, but it would be best to at least appear and tell the court, exactly, appear and tell the court that we have no interests opposing the motion, but not to appear. But maybe somebody was also assigned, maybe the person could not make it. And so we cannot really jump the gun and make conclusions. It would be quite unfair to them. And so the decision was handed down.
It's been on most of the NDC platforms. They said that Kennedy Japan scandalized the court by attacking a judge. A judge issued a warrant. He went to the Supreme Court on the basis that the judge did not ask him to come and defend himself. The position of Kennedy Japan's lawyers was that Kennedy Japan is a member of parliament and you know where to find him. So the judge should have issued it on parliament that produced Kennedy Japan and they would have done so. But to go ahead without hearing him and do that, and that's the decision the Supreme Court took. So they are thinking that it's on all fours, as the lawyers say, with this one, and there's a lot of disagreement on social media.
The issue of
that in this one, there was no way to serve him. he was not going to be willing to come. So it's clearly different if you issue the arrest warrant.
Yeah.
You know.
The issue of service, particularly for MPs, is that there is a specific way MPs are served. In this instance, Kelvin Taylor is not an MP. There is no specific instance for procuring his attendance. There's no specific process for procuring his attendance. In any case, the other side may also argue that in any case, it is still the same thing that the summons must have been issued, and then upon him failing to attend courts, the arrest warrants, because the issuance of the arrest warrant also puts some, makes him a sort of pariah. People begin to say, hey, now you arrest warrants, well, sooner, there's an arrest warrant on you, and so the court should have afforded him the opportunity to attend, and then upon failing to attend, then he would, the courts could
so
have
those who now want to sue Kelvin Taylor and those who have sued him already and obtained judgment, is it good news for them? Is it better news for them than that he's not available?
It's not, well, he has to be saved. He has to be saved. And if his location in Ghana cannot be found, they can attempt service 3 times. If they attempt service 3 times, they can apply for what we call substituted service, where he can be served through WhatsApp, he can be served Facebook, posting notice on the walls of the high courts, or the notice.
So he plays Facebook and tag him.
Yeah, you can post on Facebook and tag him.
And then the trial can start.
Exactly.
It will be assumed that he doesn't want to participate.
Exactly.
Then you go and get a judgment.
And then
whenever you can enforce it against him.
Exactly. You do what we call entry of judgment, where you detail the amount of money that has to be collected from him. And then you also attempt service of the entry of judgment. If still the process, you do it 3 times, you come for substituted service, it is posted, and then it can be enforced. However, if he is not in the jurisdiction, that is also there's a different procedure for instituting actions against people that are not in the jurisdiction.
But given that he's not ordinarily resident here, he may not change that. Is he now to be considered as in the jurisdiction or not?
Yeah, he's a Ghanaian citizen, and he lives. Well, I won't say he lives here, but
he has been here to seek legal process,
exactly,
legal redress.
Yes, and he attended. In fact, if those who were going after him may have suspected he would have been at the Supreme Court, they could have been hiding at the premises. So immediately he came out.
You had the conversation between me and another lawyer who said that he just got there and then the Prado took off and he'd taken the number of the Prado and he's doing something.
He should have sat on an Okada and chased the Prado.
He said he just got there and the Prado took off. He was just going to get the bailiffs to arrest the Prado that he was using so that national security will beat them up and then we can have a story.
Maybe the lawyer is a gentleman. Someone would have sat on an Okada and chased the Prado because once he leaves the court premises, how are you going to find him again? And in our jurisprudence, service is so fundamental.
Yeah.
If you have not served a process on a party, the courts can say, I do not have jurisdiction to.
But here you can do substituted service.
Exactly. That's it. So, and even the substituted service, there's a threshold. You have to attempt service 3 times.
At least
and
3
show
times.
the court at least 3 times.
So that you are unable to reach him.
I'm unable to reach him. And any attempt, any future attempt would
be
not
futile, yeah.
Exactly. And then the court would give.
No, I got any. Now, only for part of Wadoruma. Now, say it's a Kelvin Taylor Bagana. Now, Prophet Sabimu said, no Krebu said, no Kren, no one Casanso, ever posted, ever social media said. And some no more kind of prophet, a janda.
O media minim so abagana.
Okay, sir.
Media minim.
Okay, sir.
Me minim so abagana.
Okay, sir.
Yeah, minim.
Yes, sir, prophet.
Anyone a friend, but minim so abagana.
Yes, sir, prophet.
Toso.
And today for patron, and we answer video be a Bontia. Kelvin Taylor, every Supreme Court. Now, on the lawyers, the patron, a free bar, Omodim Kunim. Judge, I know what say German say Kelvin Taylor. I can send me a fan home. And some of what can find one thing, prophet. Or the bench warrant, and they are told Kelvin Taylor so said, "Baby, a police for who be a month and for them court."
Baby, a police for who no them court.
Me patcho
Baby, a police for who Obagana or them court.
O month them court.
Nemo way inviting and said, "What say no way into one remaining one."
There be patcho there be.
And we said, "No, Yajuma, Judge and so a bassa one yard." So, cast a police for them court. Nay, say, would need 2 one a beba. Yemo Ebia, as some say, no waka, etia court no. And Tibrabe you one on the one. And no, or be in one, of which obituary will be a cranny a chin never so be any day. In his review, so I know said me too. Brabe you one, yes, and any children difference room.
Yes, and take away 4 against 1.
And a seminal, I feel no media and I see a term.
Prophet, Omo trust him in part.
Okay, and 1 year the radius.
Omo trust him.
Radish, the way we used to demo. Now, Kelvin Taylor, a radish, a quab so, you more quab or Ghana. Obayache, a rather more mobile. So, best I could do a studio any here. When I may a mad what day and idia way, it didn't to me in ye, Emfa, and Mount.
As if I could Kelvin Taylor so.
Why?
As if I
to be for myself. Kelvin Taylor, my money before also.
I beef Kelvin Taylor.
Also through.
Kelvin Taylor the catch him say and go for Tali Coco so don't Ajagurajah. Maybe I saw this one house of you. Ask anybody. I'm not scared of anybody.
Say on the punch, no, your heavy punch.
What now? Maybe some punch. I'm the man in heavy punch.
Or prepare ba.
And I
said the Ghana has it to be to
I don't know who's all Ghana.
Or any court.
And on one court.
Yeah, no, on one court. In fact, last time no so or the court no. A idea judges are bogu say bench warrant be in the subium.
So, and Kelvin Taylor Ghana.
Kelvin Taylor Ghana.
I'll meet you. I'll meet you. So I can't go for something or matter what something. You can go on your Kelvin.
Case in what about no see uncle.
Already na bekuru.
Already na ba.
Abekuru.
No must say day. Mami educate you omo. Say na no betena ha. Na mon ka no krenti. Mon fa me bo mame. Say mo de me bo mame a. Me kan sansa daily die na ye no kre. Ana ye pamo no. Well you so full computer ne one typewriter. Was so ye doctor so ye doctor. Me be kan wa ha. He say doctor no ye free din so. Nya sa. Ani ye na omoko fa ambulance die bai. Eno so me kan ye no ye ko hwem no kre ye yapam no. Me buy me say kokohwedie bola bedi o kroma last week na be kan etimunti mi nkasa ne kadachie ne fela na ekura no ay authentic if say bola bed no wramu bia me hunu na ne yebehwe de state in waye say we immigration service say we police your national security na warrant da obi so na otimi wram eba ema state no abo ne ho ban na state ne bo ne ho ban wi a na state na sa de na court no na issue warrant no court ne se na ni ehu na so ante na court ne se wa ba begina na nim wa bra court na order say warrant da so eti ko na later you make any determination waba ojina court ho em yes ubatiane warrant na fe ye musa first of all ye ka say obi aye contempt of court kura ye de ba dia de ba ni nyina no asem no aye kan nyago bi ye ka contempt of court one and ye be hwe what is contempt of court
Educate.
Say na no me be kire mo say me kire mo petition no odi akọ grounds odi ko ye nyina o say eye justice Chebafo who is a court of appeal judge at that time sitting for extra responsibilities as a high court judge it will be a court of appeal judge na case be cause of high court it me man ba betna so but at that time so what so on so as a court of appeal judge but so as a high court judge at that time now justice Chebafo a court of appeal judge by a number ebedi case na case no obedi no ye be hwe manfo no asem why
Exactly.
Obi you know ye ka say contempt of court ye will be a friend CI 47 that is a civil procedure act CI 47 civil procedure ni ye ya say o court ye the procedure to ho and emra na ka say ye mra enya hye procedure say ni na say fa so a say fa so pepepe ne kwa say chia no. Now, then he zoom in. Now you ready a year order 50 of a civil procedure act. That is CI 47. Our court no say wodi asemwa. Sa nyoma no faso. Now you can order 50 rule 1. Chenio. Baby a justice Chebafo fa the contempt in free here. And the Supreme Court so munti bi da no. Now, offer a year order 50 rule 1 of a year committed for contempt. You can't contempt ya. What book court name tia? Near Frewo. Now, I see the power of the court to punish for contempt. Genio of the court may be exercised by an order of committal. 2. Committal proceedings shall be commenced by an application to the court. 3. The application shall be supported by an affidavit stating inter alia. You can inter alia. Just say among other things. Say o kasem na di be kaho. And then I say it shall state inter alia. And a Latin word for among other things. Inter alia the grounds of the application. Now 4, subject to sub rule 5. Sub rule 5 you better read it. Say you can rather subject to bibia. That means you conquer baby or subject to no. Say o musi atwero we die. Nanso yensan kan we was subject to sub rule 5. The notice of motion together with a copy of the affidavit in support of the application shall be served personally on the person sought to be committed. Now, lastly, that is sub rule 5. Also, without prejudice to its power, under order 7, rule 6 of the court may dispense with service of notice or motion if it thinks it is just to do so. The Ayakam Brofuntin say, okay, order 50, rule 1 of a civil procedure, that is CI 47, or say, court ama order CB, say Abia Kofid Mako Court, General Mako Court, and a court when I make you orders, said yes, a medium fee. Now put in the court, say what you defamation. Now court in the ruling say 1.5 million. A best in a medium fee 1 city. It's na poverty me a court, and so do be court a 10 million. Who would you work your award against you? I won't try. Afe say na poverty me a court. If the court do make you order, or no one should be bia. Nemo no say nipa na mu order na court na ye na poverty me a court. Akoka kire court ne say wo order na wo ma asame jamfi. Say on try me 5 million. On try mu 1 cedi kwa. Nemo make sa order na application no supporting with affidavit ne de kekeka wo. That is one way our court no be ka say. And now say wo ye make you order when you suntino. Bra for contempt.
Precisely.
Ti nipa no apply.
Indicates.
Nemo mono there are also instances. Dani yanko ready a sub rule 2 near radio. Catch them you be educate you. Why? You be educate. You be share definition for contempt. By definition, a person commits contempt and may be committed to prison for willfully disobeying an order of the court, requiring him to do any act or any act other than the payment of money or to abstain from some act. It's where a definition of the court. A contempt. Now yanko a sub rule 2. Or the 50 sub rule 2. It medical chira or coin back a faswa. It make us a court number order. Now wo bunenimtia. It may make application to the court. Say court name fro. Never chirem the entire wo bunenimtia. Nemo mono there is also order 50 sub rule 2 which says otherwise. Then if I not to sonianko. But before that, then if I make a year article 1262, Nyanko Radie,
more fire.
Kofi yakasa contempt of court. Superior courts, omo pen na wo to me so omo ye contempt of court. Na yaka superior courts na court ni achemu mienu. First na komo ka superior and inferior court. Na yanka inferior court bi. We say the lower court. So superior courts ni eden. The high court, court of appeal and supreme court. Now the lower court, circuit court, district court ni eden. Now Yankai Article 126. Or say the superior court, which is high court, court of appeal, supreme court, shall be superior court of record. Now the entire one says shall be superior court of record. And it said, the superior court need the assembly we now o make a decision. Your friend is stare decisis, which is precedent. Now precedent and no be make sure say other lower court so mo make a decision biana. They won't depart from the superior court rule. It was said the superior court shall be superior court of record. It is a court was here, a circuit court. Ne district court mo di case ya o mo ba hwehwe the decision of the high court no mo dia rule sa so na high court nsu dia high court no hwehwe the decision of a court of appeal and now supreme court no dia rule na court of appeal no ono any decision ono so ba hwehwe supreme court decision no dia rule na supreme court there the decisions are binding on omwankasa etiade supreme court wa yi until such a time that supreme court no can depart from the decision no my and emrane mo kwan e mo set decision omutimi depart na yen ready or say the superior courts shall be superior court of record and shall have the power to commit for contempt to themselves and all such powers as were vested in the court of record immediately before the coming into force of this constitution. It is justice here for so odi asem na Otchere so emrane man ho kwan say obenya to me and committed to the whole contempt say what bu court na nimtia what bu meme nimtia eno na ogina aso no ye na yenko ready for the 50 sub rule 2 na yen hwa de already on the 50 sub rule 2 or say committal without application don't forget say ba ko ne ka say yes obi ne making application but the mrane ma inherent power to the court say so obi a making application na judge bi ehunu say ade no amoka no e book court na nimtia or say the court has an inherent power. So he says nothing in rule 1, that is our application, affects the power of the court to make an order of its own motion against a person to show cause why the person should not be committed for contempt of court. It is Justice Cheba for AUSU order 50 rule 2 and was say be the case what's akwawi bolabadi what na ho akikansem I go me who fee eku court no fee na Supreme Court High Court no constitution am to me to commit unto themselves contempt sanso na order 50 rule 2 no eno so momo kwan e di Justice Cheba for afre and wa twere order ama court no say police for so momfa akwa we mra na Kelvin Taylor asemu a work and bola bed na asemu a work and say tieni o ya ma ne kwan ametie na numu asebo ansa ne issue warrant. What are we talking? Now Supreme Court is one in the argument. It beats a natural justice. Medical culture was a natural justice and never me no. All the term pattern. Everybody deserves a hearing. And no more Judas in Casaswa. You cannot be a judge in your own court. So ordinarily, you cannot be a judge in your own court. For you to see how contempt operates, when it comes to contempt, the Constitution gives the power to the High Court, power to the Superior Court judges. So judges in their own court. It tells you how contempt of court is prohibited by the Constitution. If it's a Constitution, person will book court no limtia. And in here, several constitutional democracies. That's what we have.
Exactly.
Now, young Congo here. Kelvin Taylor say yentie no na Supreme Court say I am pa yentie no Kelvin Taylor say na esenki Supreme Court Justice Cheba for edika ka say bra na ebe kire die ntia na o refuse na afi ye issue warrant tienio ewa bra order 50 rule 2 echiremu clearly say court no when they feel that you have been contempted ombetimi order say bra now oko ready dani fameko ni ready you can say Criminal and Other Offences Act 1960 Act 29 Section 10 of Act 29 when him say almost ordinarily police in Bechiwa will use warrant but them running him said there may be instances where the police must prevent crime and harm Wasama police need to me say when a crime is being committed in your face and you have na aba besina court akwaji warrant aba the mischief is seeks to cure is that it will work Criminal and Offences Act 29 Section 10 or say arrest by a police officer without warrant. It is my whole coin. The Supreme Court ruling jina dia. The omopa chere say police in the class will be the bonia. Just all court no. And the court cannot even issue warrant first. Name of court no eso ka say. But I bet chirem the entria udi sa bone no. Na chiremu wi a ansa na yebetimi issue no what be that. Supreme Court. Hey, where the more if Samoka say yentie Kelvin Taylor na yet wa court when it was the essence of the warrant. If the yentie issue warrant no is that you see police for national security, immigration, so much say ni paya mo fa ni mra manim na o mechire yentie any kwan see a committee to jail. Now you ready order na Justice Cheba for make here. Now you ensure the wording of the order. Order yesterday. I say bring him.
Exactly.
So bring him no. And yes so do ani throw say ko jail. Because of the nature of contempt. Kobi yemra no on trust specifically. Punishment e ma contempt. It remember kaya contempt cases under John Dramani Mama. Time a year election petition. And omo ye na yesame oku. Oma ko kan bibi. Supreme Court no hwɛ o man say wo yama won e kɔ enso Kenneth Eje kwanchi kodu no ye de ne to jail sanso na atu biga ono so ye de to jail ana ayi muntie trefu omo so ye do mko jail so Supreme Court is a contempt is in such a way that the court will decide what punishment to give you it is nyasa bola bedi se na adwene mu ha ana ne lawyers no wo mudi nkwasese mu anka this was even a perfect opportunity for us to have a conversation on the opaqueness, or so to speak, the absoluteness of the power of contempt for the court. And then I really this was your friend big jurisprudence. You can't jurisprudence, and that means emrano because in you must see every day. No, we must develop the law. The law must grow, and the law only grows when you challenge the law. So sakwa ya gini ya jumapa, and also all fighting for the people. He should rather have gone to court for us to have a conversation on the whole contempt and the absoluteness of the powers that is given to the court, for them to now arrogate unto themselves. So now you more hunting, Ghani, Eddie Akose Day, Yenny warrant in free so. Now, dear one say, it's time of free fee, Ojare. That moment, no warrant near active. National security, national security car. And a coffin, and I say this on authority. Medical number 2. Medical and number 2. Now, question national security car. Mama, you see, we will be serious as a nation. National security and a far and an page in so. Now, F card number 2. Now, mention Mokwaya, your first check a year car number plate. Say insurance will home and now insurance in one. I want to say national security can no issue. Make sure said you see no. It's national security kofa bolabedi. I would need free fee. Abesina court one. There was an active warrant on him. So at no point should he have been protected. Rather, he should have been arrested, put before the court, which is a just chamber first court. Then once the court is ongoing, they will say that we filed an application at the Supreme Court, for which reason the court must stay. So per the Constitution, whenever High Court is hearing any matter, Nasa Obiko Supreme Court for interpretation, the High Court judge is supposed to stay proceedings and wait for a determination to be made at the Supreme Court. And so when I give him and person and pagan and develop here, and court justice for anymore. No more refer say yes, stay proceedings because there is a determination to be made at the Supreme Court. I will going to ball up and I'm going to say G. Now I said we see homie no mask anymore. When I saw Bema, now we'll free court to be I am more than a bobre. We Bema, we as a cocoba. We as a winter coat. No hanging coat. But you know, Nipa way you we are dear winner. A dear winner, Timothy didn't part of you. When I did have an pony and Yina Horn and Passo. Wait. And then is zooming in near us and was your home. I said, oh, home trade war. I did him. Then you quite no more. Quite I could have no more rested was your home. Oh, criminal Yahoto.
Of course, I have a authentic plus to make sure. So, like you best subscribe and share. I'm a full friend to any. Ashe.